Have you heard that your parishioner, the defendant, submitted 5 applications to 5 different banks for loans, each of which contained a false statement? Have you heard that?
No.
Okay. And if you heard that, would that change your opinion as to whether she's an honest person?
Probably.
Okay, thank you very much. Okay? That's the other way to cross-examine a character witness. Right? Now, do it differently. Say it wouldn't change your opinion. Would that change your opinion?
No.
Because you don't think lying to a bank is a big deal, Father? Right. So you really can't lose. Whichever way he goes, you're going to be okay, right? So now, can you do it? Look at 405. I just want to point out, having the acting skills to be both a district attorney and a priest in one evening is an impressive performance. Here we go. 405A, on cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct. And that's what we did. Now, a couple things. One, they have to be relevant, but this is about truthfulness, so they're relevant, right? 2 is that the purpose of this is to test his ability to speak for the community or even for himself. Right? So the rule allows this kind of question. And that's the other way to cross-examine a character witness. 3 is you need a good faith basis. Right? You can't just say, have you heard that you lied to 5 banks? Objection, we go to sidebar, and the judge says, what's the basis for that question? And you say, I was just trying. Right? That is a good way to get disbarred. You need at least so in those situations, I have the documents. Right? Now, she did apply to banks for 5 loans. In each one, she had a false statement. She wasn't charged with it. I don't think I could have gotten into evidence otherwise unless she testified that she didn't. But by calling a character witness, she opened the door to that cross-examination. And that is a bad thing if you're a defense attorney. You shouldn't call character witnesses unless you know there's nothing out there that's going to come to bite you. Right? And if you're the prosecutor and you're going to ask that question, you better have a good faith basis. And typically what I do or did when I was a prosecutor, the direct examination's finished. What's her reputation in the community? It's great. Judge, may I approach the bench? I go up. I say to the judge, here are 5 loan applications. If you look at them, you'll see that she's lied on all of them every time when they say the value of her property. They're all submitted around the same time. It keeps rising, dramatically, different, whatever the false statement might be. And I'm going to inquire about it. I just want to give the court a heads up. Because if the court says, if I do it, and the court says the question was improper, I may cause myself a mistrial. Right? I may really create problems. So he's playing with fire by calling a character witness. He better be sure there's no bad acts there, because if there are, the prosecution is going to cross-examine about them. Right? And I'm playing with fire as a prosecutor because I better have a good faith basis for those questions. And sometimes as a defense attorney, I'll say to the prosecutor, depending how close a relationship I have with her, look, I'm thinking of calling a character witness. Are you going to hurt? You have anything that's going to be hurt the character witness? Because if you do, I probably won't call him. And sometimes the prosecutor will say to me, look, trust me, you don't want to call that person. Okay? Well, what do you have? Look, trust me, you don't want to call that person. And if I trust them and think they're an honest person, I won't. Right? Sometimes they'll say to me, when I want to know what I have, here's what I have. Okay, I don't think I'm going to call a character witness. Right? Because you're opening the door to that cross-examination. Okay, now, let's do a set of problems and make sure we understand it, because it's not self-evident. Let me say a word before the phrase not self-evident. There is in your material a case called Michelson. And Michelson is an old Supreme Court case. It's a Jackson opinion. It appears in page 121 in your book. I don't know how many of you know Justice Jackson, a great New Yorker. I think he may be the last Supreme Court justice not to go to law school. I think he apprenticed with a law firm in upstate New York. He was a New Dealer. He was, if not Attorney General, Solicitor General, and Roosevelt appointed him to the court. He briefly left the court to become the prosecutor in Nuremberg after World War II and returned to the court. And Jackson was, I think, in most people's judgment, one of, if not the most eloquent writers ever to sit on the court. And I've always loved this Michelson opinion for its last paragraph. So look at page 124. And look at it both for style and substance. Here is Jackson in the last paragraph on the left side of 124. We concur in the general opinion of courts, text writers, and the profession that much of this law, the law being what is now 404A and 405, is archaic, paradoxical, and full of compromises and compensations by which an irrational advantage to one side is offset by a poorly reasoned counterprivilege to the other. But somehow it has proved a workable, even if clumsy system when moderated by discretionary controls in the hands of a wise and strong trial court. To pull one misshapen stone out of the grotesque structure is more likely simply to upset its present balance between adverse interests than to establish a rational edifice. That's pretty good writing, right? And that is what your drafters decided too, that they were just going to take the common law procedure for the most part. They were going to add that you can ask about opinion and not just reputation, but they were going to leave the sort of crude compromises that you couldn't ask about Hulk Hogan or roaches, that you were stuck with reputation, opinion. On cross-examination, you could inquire into specific instances. So now let's see how those compromises play out in practice. So turn to problems. And here we go. And we are, we're at 142, number 1. D is on trial for bank robbery. The state calls W1 a teller who identifies D as the robber. The state next calls W2 and proposes that W2 that he is familiar proposes that W2 testify that he is familiar with D's reputation in the community and that D is a known crook. D objects. What ruling? Yep.
Totally permissible.
Because?
It's directly contrary to 404.
Because?
Because the prosecution can't do it.
Prosecution can't go first. Right? And at the break, a French student was sitting here in a white shirt, but otherwise is unidentified, came up and said that when Dominic Strauss-Kahn case was dismissed here, he went back to France. You may recall that he was tried on charges of, I think, organizing a prostitution ring. That the first 3 days of that trial were all about Dominic Strauss-Kahn's sexual habits and use of hookers and prostitutes. That 404A was said to me that is the opposite of 404A, and it is. 404A says the prosecution can't begin this. Okay? Number B. In his defense, D calls W3 to testify, D is our bank robber, that his reputation in the community is as an honest, law-abiding person. The prosecutor objects. What ruling? Yep, keep going.
I think that would be admissible under 405A.
404A to begin with, and then question is permissible under 405 is the form, right? And that is reputation. What if they'd asked about opinion?
I think it would also be something.
It does indeed. Assume W3 testifies as proposed. So we now have a character witness who says this person is of good character, he is an honest, law-abiding person. And our character traits are just that broad. On cross-examination, may the prosecutor ask W3 whether he heard that last year D swindled an elderly lady out of her life savings. So, sir, you've testified that the defendant is an honest person. Have you heard, and that's his reputation in the community, have you heard that last year he swindled an elderly lady out of her life savings? Permissible?
As long as he has some basis for saying that actually didn't happen.
Better have a good faith basis. That's Nixon in your cases, right? Okay, ready? Same person to answer. If W3 has testified, after W3 has testified, D rests. May the state now reopen its case and offer proof that W, in fact, swindled an elderly lady last year. In other words, may it call her. Okay. Anybody? Yep.
I think no, because that's like a propensity crime because he may have done something in the past.
Okay, and what if, look at 405 with me, right, because that tells us something about form. On cross-examination, what does it say? What does the second sentence of that say?
Relevant instances discussed.
Go back further in it. Read the whole sentence.
When evidence of a person's character
Second sentence, just the second one, I'm sorry. The one that begins on cross-examination.
on cross-examination of the character witness, the court may allow an inquiry into relevant specific instances of the person's conduct.
And so what tells you in that sentence structure that you can't call the woman? Yep.
It's a cross-examination?
It is cross-examination, but there's one word in there that tells you I can ask the question, but even if the person says, I don't know that and it wouldn't affect me because I wouldn't believe it. Right? Then the question is, well, can I call the witness? What word tells me that the answer to that is no? Yep,
Inquiry?
that's it. In other words, that rule allows inquiry. It does not allow the witness. And so all I can do is ask the question, as lawyers would say, I'm stuck with the answer. Okay? Why? Because otherwise we're going to wind up with a trial about whether he in fact defrauded that woman. And what we're trying to try is that he robbed the bank. Okay? So again, this is 403-like. We're not going to let this case stray. We're going to allow, and this is what Justice Jackson means by crude and irrational compromises that balance each other out. Right? I can ask the question, but I'm stuck with the answer. Okay? Number 2. D is on trial. We'll make it a criminal case for securities fraud. In his defense, he calls W to testify concerning his reputation for honesty and integrity. Character witness, testimony, honesty, reputation, opinion if he wants to. On cross-examination, the prosecutor asks W whether she is aware that a year after the alleged securities fraud, D was fired from a job at the bank for embezzlement. G objects on the ground that the incident postdates the offense for which he is charged. What ruling? Right. Isn't it a fact that after the crime he's uncharged with, he went to work for a bank, and have you heard that he was fired for embezzling money from that bank? Okay, specific instance, I'm asking, I'm inquiring, I'm stuck with the answer. If he says I haven't heard it, I'm stuck. But the question is, can I ask the question? It postdates. Yep.
I think it would be admissible because the rule doesn't limit it to prior consistent conduct, only any consistent or inconsistent conduct.
Is it any, or what's the word the rule uses?
Relevant specific instances of the person's conduct.
Just right. And this is relevant, particularly when the question is this character witness really knowledgeable about his character? So I can ask about these subsequent questions, because the question is, do I have a character witness? Now, what if the question was, okay, so our question is, he's honest, right? and I say to him the following. Well, have you heard that he was investigated, good faith basis I have for this, or whatever, committed, whatever word I use, child abuse? Can I ask that question under 405?
I don't think that's relevant.
Okay, and that's how you decide it. The character trait here is honesty. I don't mean to say that you can necessarily be an honest child abuser, right? But child abuse doesn't speak much to honesty. If I said law-abiding, that question might be permissible, right? But I'm allowed relevant instances on cross-examination. If I said violent, what's his character for peacefulness, right? I could probably ask about the child abuse event. Okay, last one. Number 4. P sues D for breach of a stock sale agreement. D asserts an affirmative defense that the agreement is not binding because P and attorneys secured the conduct through economic duress, undue influence, and conduct inconsistent with professional standards. P moves to disqualify D's attorney, claiming that he intends to call members of the firm to testify to his good character. How should D's attorneys respond to the motion in order to avoid disqualification? So you are an associate at the firm. The partner comes to you and says they want to disqualify us because they want to call us as character witnesses. This is a big fee involved here. Go to the library, research. There must be an answer to this. Can they call us as character witnesses? And you say, because you're well-trained, I don't even have to go to the library, sir. I can give you the answer off the top of my head. And the answer is? I should tell you the response is that it's a large bonus for you. But go ahead. It's a civil case, right? And this exception begins in criminal cases, right? So there's a large bonus for you. But this rule it's a mercy rule, as people say. That's why I like to start with a Hitchcock play. It really only applies in criminal cases. Okay? Okay. Let's look at a couple things real quick, just to conclude this. Look at, start with 140. And I guess one other thing to say is, remember, 405 says inquiry. The court may allow inquiry. It doesn't require it. The court still has the ability to say, look, I'm not going to let that. I think it takes it far afield, or I think it's more prejudicial. But may gives the court discretion every time that word appears. Okay, so look at page 140, and here is what one typically instructs a jury at the bottom of 140. After the witness testified about the defendant's reputation for honesty, the government attorney asked some questions about whether the witness knew that the defendant had been convicted of fraud. Those questions were asked only to help you decide if the witness really knew about the defendant's reputation for honesty. The possibility that the defendant may have committed those crimes is not evidence that he committed the crime for which he's on trial. I remind you the government must prove the defendant committed the crime and must prove it beyond a reasonable doubt. That may be a limiting instruction also that no one can follow. Right? What I'm saying is, you heard evidence. The question was, and have you heard, Father, that 5 times she submitted false statements to banks? Right? Limiting instruction. That was only asked to see whether he was in a position to speak to her reputation, how much he knew about her reputation. But don't take it to be true. Right? It was just asked. Its questions aren't evidence. But boy, you sit there in a trial, and that question is asked, and you say to yourself, I can't imagine they let him ask that question if it wasn't true. Now, the truth is they couldn't ask him unless there was a good faith basis for it. But that question kills you if you're a defendant, right? And the limiting instruction doesn't help that much. It's meant to say, hey, it was just a question. But if you're a juror, I think you hear it and you say, you know, where there's smoke, there's probably fire. Where there's a question, there's probably an answer. And most likely she lied on 5 applications. particularly when, if you ask the question, you hold all 5 of the applications in your hand and you say, Father, have you heard? Right? So the sense is there must be something there. Okay, you ready? That's the bottom of 140. Look at the top of 139. This is another of those U.S. Attorney's Office emails. If anyone has researched the issue of what types of evidence may be used to rebut character witness testimony or has any knowledge on this issue, I would appreciate hearing from you. To which you want to say, read Rule 405, right? The second sentence. But here we go. If that request appears overly broad, consider this. In a trial for possession with intent to distribute heroin, defense lawyer puts on character witness who testifies that they have never known defendant to use or seen him possess narcotics. Now, you should stop right there and say to yourself, that is not permissible. What is permissible is simply, what is his reputation for law-abidingness, right? Not that kind of question. But nobody seemed to object to it, and the judge allowed it, and the answer was, I've never seen him use it. Prosecutor knows, and is turned over to defendant, of Marshall's intake sheet on which defendant admitted heroin use. Is there a theory of admissibility for the prosecutor to put in rebuttal evidence through Marshall of defendant's admission, right, and so forth? Now, the answer is there shouldn't be, because that is not inquiry. That is proving it up. It may be that given how bad the question, the defendant got away with, I've never seen him use it, it may be that they opened the door to it, and we'll talk about that. But if you're playing by the rules, you should not be able to call that Marshall, because all you're allowed on cross-examination is inquiry. Okay, let's see what else we got. Go back to 138. 138 is an affidavit submitted by a Paul Weiss attorney in a case at an upstate university where a young man, Mr. Bailey, was charged, I think I'm right, with a sexual assault. And the last paragraph of the affidavit is what interests me. Number 9 on page 138. On March 19, 2004, the Friday before the start of the trial, I contacted the defense attorney by telephone and advised her that I may be present at certain times during the course of the trial and wished her luck. We discussed the case a bit, and I asked her whether she considered calling character witnesses. Specifically, I'd mentioned 2 professors at Utica College who had close ties with the defendant and thought very highly of him. The defense attorney advised me that she could not call character witnesses unless the district attorney chose to call character witnesses of its own in the prosecution's case. This did not sound right to me, but I've been out of criminal practice for a number of years and did not question her. And of course, it's not right. It's completely backwards. This is a door the defendant opens first, and then the prosecution can rebut by calling character witnesses. It's not the reverse. And this may have been a case, right, where it made good sense to call character witnesses, but most likely this young fellow did not have any other blemishes, nothing else on his record, nothing hidden, and there wouldn't have been much cross-examination of the character witnesses other than you don't know the evidence in this case, right? So this might be a case for character witnesses. I have Norman Seabrook coming up. He's the defendant in a trial in October, former head of the Corrections Officers Union, and I'm thinking about calling character witnesses. And Seabrook was close to Governor Pataki, he was close to Mayor Bloomberg. I don't know what the prosecution has other than that they're going to try him for bribery. I don't know if they have other evidence. And so I'm trying to decide, is it worth the risk? Should I ask the prosecutor, do you have anything else? Same questions that come up every time you think about a character witness. The last thing I want to do is call a character witness and have the question being, are you aware that he has 5 false applications to banks? Right? If that's the case, I don't want to call a character witness. Okay? That is 404 A1. And if in 2 seconds on 404 Let's go back and look at it again, 404A2. And this is a complicated rule of which the only thing I care that you know is the very first part of it, which is B says, subject to the limitations in Rule 412, we'll come back and talk about that, a defendant may offer evidence of an alleged victim's pertinent trait. If the evidence is omitted, the prosecutor may rebut the same. Typically what this is a defendant is on trial for assault. And his defense is, self-defense. I did not start this. He came at me aggressively, and I simply defended myself. And now I want to offer evidence that his reputation is as an aggressive person, right? So that it's consistent, it supports my defense that he was the aggressor, I wasn't. The rule allows you to do that. The rule then allows the prosecutor to call people to say he was peaceful, all subject to 405, opinion, reputation. Okay? And it gets more complicated after that. Do not worry about anything after that first sentence about the victim. Okay. I should tell you the following. This is the wonderful thing about this law school is that one hopes you're taking an evidence class either because you're interested in trial law or you really like Tuesday night 6 to 9. There's nothing good on TV. I'll interrupt again. I talked to a client being interviewed on Thursday, and I get a call saying, we may go late, it may go as late as 7 o'clock. I want to give you a heads up. Is that okay? And I said, I have to be home by 8. So you think you can dance starts at 8 o'clock, and so that's really my cutoff. And she said, well, I promise you'll be home for that. But in all seriousness, one of the great things about Columbia is this is not a bar review course, and people, you try to teach evidence so that people think about purposes of things and statutory interpretation and how the rules should be and how they are in other states. But Saturday I spent at this resort on Lake Champlain writing questions for the bar exam, which is this great gig that I now have, with 5 other people. And somebody asked a question about 404A2C, to which everyone agreed, oh, nobody teaches that or knows anything about that. You can't ask that. I said, I don't know about nobody, but I don't teach that. And so I'm happy to hear that we're not asking that. And in all seriousness, it gets complicated in there. And so do not worry about it. Just sort of have this basic sense that the exceptions here for character evidence are the defendants using it to show good character, and there is an exception that allows in self-defense cases the defendant to show the bad character of the victim. Okay? And the subtleties, I promise, will not be attested by me or by any bar examiner. Okay, ready? We get to our final topic of the evening, and that is 404B. And this is a hot topic at the moment. The advisory committee is reconsidering it. The 7th and 3rd circuits have new opinions. They are, in my view, too long to be included in your materials, but I want to talk about them a little bit. And so look at 404B with me. And I think I said to you 403 is the evidence rule that is applied most often in a courtroom. Good trial judges are judges that balance prejudice and probative value. In terms of appellate law, probably 404B has the most cases. Right? And here it is. Evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in conformity with the character. Right? So evidence that Dominic Strauss-Kahn has been with hookers before is not proof that on this occasion he was with a hooker. Right? That's the prohibited use. Permitted use. This evidence may, what does the word may tell you? Discretion, where you're going to get your application of your discretion, Rule 403, may be admissible for another purpose, such as tells you this list is not exclusive, proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake or lack of accident, and then a notice provision that we'll talk a little bit about. Okay, so what is this about? This is what everyone calls other crime evidence. Now, it doesn't have to be a crime, it can be a bad act, but that's not a bad description of it. It says I can't prove character. I can't prove a specific bad act to show that he acted in conformity with it. And so the impermissible inference goes like this. Bad act, right? Bad person. Right? Committed this crime. This crime being the one he's on trial for. Okay. Now, unlike 404A, 404B is not limited to civil cases. So it could be committed this wrong if it's a tort case. But look at the structure again. Evidence of a crime, wrong, or other act is not admissible to prove a person's character. Bad act to prove his bad character in order to show that on this particular occasion the person acted in conformity therewith. So that chain of inferences is my forbidden inference. Right? This is an Article 4 rule. The structure is the same. A forbidden inference, permissible purposes. What are the permissible purposes? Such as motive, knowledge, intent, identity, common plan and scheme. What I can't say is he committed a rape, right? He was convicted of a rape, therefore he's a bad person, therefore it's more likely he robbed this bank, right? That is 404B in its strongest prohibitory form. Right? He committed a bad act, he's a bad person, therefore he's more likely to commit a crime he's on trial for. Okay, now, some examples. So remember, we start with the word such as, so that list is not exclusive. So let me give you an example of another crime that is not on the list. But this is an old case called Carter versus United States. The defendant is charged with possession of a gun. And the story is that he came in to fill a prescription for narcotics. The druggist noticed that the physician's name was forged. He knew the physician. He did something that gave the defendant concern that he'd been caught, right? That at least the pharmacist was aware of this. The defendant ran out, ran past an alley, threw the gun. The pharmacist gave chase, and our defendant runs right into police officers. They go back to the alley, they find the gun. That's the charge, possession of a gun. Okay? And what I'm going to ask is if you will be the pharmacist, okay? And let's do it. Should we do it the reverse? No, you be the pharmacist, and I will be the lawyer. And we're going to tell this story without mentioning the forgery. Okay, without mentioning that you saw that it was forged and that's what caused all of this. Because that's an other crime that he's not charged with. So you ready? State your name.
I'm pharmacist.
Very good. And with that name, how are you employed?
I'm a pharmacist.
No wonder. I want to direct your attention to August 3rd of 2016. Were you working that day?
Yes, I was.
And will you tell the jury what happened? No mention of the other crime now. Go ahead.
I don't think I'm clear on.
You're going to tell what happened, but you're not going to mention anything about the forgery because he's not on trial for that. So go ahead.
Sorry, I wasn't listening carefully when you said
Do I have another pharmacist? You know, you've given your name. Anyone else? Can you do it? Go ahead. So you're the pharmacist.
Yeah.
Good. And were you working that day?
Yes.
Tell the jury what happened.
Man came in. There was he went to the register. After a little bit of time, he left in a hurry, and that was the last of it.
I know you chased him.
But
You're not. Okay, keep going.
as I chased after I followed him out, I saw him dish the gun in an alley, and that was when the police.
Perfect. Okay? Now, if you're a juror, you say to yourself, God, that is the weirdest story I've ever heard, right? Guy comes in, he comes to the register, next thing you know, he leaves, and the pharmacist chases after him. Right? What was that about? Right? So, most judges, all judges, will let you tell that story in a way that includes the fact that he approached, and I thought this was a forgery, and he seemed to notice, and I gave chase, right? Because otherwise you can't tell the story. Now, you're probably going to, at least on request, you may instruct that he's not on trial for forgery. Whether it is or isn't a forgery isn't a concern for you. But we are proving another crime for which he's not charged. That's what 404B is all about, right? And here we're doing it not to show he's a bad person and he acted in conformity with his character. We're doing it just because it's the only way you can tell the story in this case, right? And that purpose isn't listed, but that list is not inclusive. It says such as, right? And if you look in your material, you will see on page 152 a case called Gonzalez, where other crime evidence is admitted to complete the story. And the last sentence, the Second Circuit says, right, last paragraph on 152 of Gonzalez, finally we reject the 404B claim. It is well established that evidence of an uncharged criminal activity is not considered other crime if it arose out of the same transaction, inextricably intertwined, or if it's necessary to complete the story on trial. It is well established, except that now 5 circuits have said it doesn't make any sense, right? This is another crime, whether it's inextricably included or not. Professor Capra and a very fine professor from Oklahoma will have an article coming out in the Columbia Law Review where they say this notion that it's not 404B evidence makes no sense. They're right. This is other crimes evidence. It's just offered for a permissible purpose. And you can't tell the story without it. So my own sense is you have some circuits still saying that if it's inextricably intertwined, it's not 404B evidence. But the short answer is it is 404B evidence. It's evidence of another crime. It's a permissible purpose because you're not using it to show propensity. Okay, so that's one example of 404B. Ready? Second example. When I was at the U.S. Attorney's Office, we had a case, the drug deal went bad. The victim, the father failed to pay for the drugs. The result of that was they kidnapped his son until he paid. Right? Now, and the charge was kidnapping. The drug deal going bad was the motive for the kidnapping. Right? Motive is a permissible purpose. It's not he's a drug dealer, therefore he's a bad person, therefore he committed a kidnapping. It's this particular drug deal went bad, right? That's why they kidnapped the child, and that's proof that of motive to say that you have the right person on trial. You should know that the defense was this wasn't kidnapping; it was a secured transaction, and therefore it shouldn't be charged as a kidnapping. I've never thought that was a particularly powerful defense, but this is not offered to show that he's a bad person. It's offered to show the motive for the crime. Okay? Now, appreciate the following. When we talk about 404A, 404B tells us you are limited to opinion and reputation. Right? 405, rather, tells us that. When you talk about 404B, you are proving up acts. So you are having, in a sense, a trial within a trial. Right? You're not limited to opinion or reputation, because I don't say to my pharmacist, what's the reputation of that guy who came in? I say, what did he do? And the answer is, he presented me what I thought was a forged prescription. Right? So, and similarly here, why'd they kidnap your kid? Because I was involved with a drug deal with them and it went bad. Not because they have a good reputation or a bad reputation, or in my opinion, they're bad people or whatever. Okay? Next, knowledge. That's a listed exception. What's an example? You are charged with trespass on government property. You're on trial. Your defense is you didn't know it was government property. Okay? Next case, you are charged with trespass, same government property. 3 weeks after you just got acquitted. Right? They're going to be able to prove something about that first case. Because, I mean, it may just be that, the question may just be, did he sit in a courtroom for a week with a map up that said in red letters, this is government property? Right? You may not have to prove that he was convicted, that he was tried for it, right? But you're going to be able to prove that he knows this is government property because of his prior case. So one way or another, the jury's going to learn about that. Remember, the word may is in there, so you may try to pull the poison. You may not try to say who was on trial. But God knows we're going to not let this guy keep getting acquitted based on a lack of knowledge defense when he sat there for 2 weeks with a map on the wall. Okay? What's another example? There's a wonderful woman in the city named Curry Martin. She was a Rehnquist clerk. She was particularly close to the justice. She was a pallbearer at his funeral. She went on to be an assistant United States attorney and then left to raise children and has been actively involved in life in the city. Curry's first trial was a bank robbery. And as she tells the story, the guy who she was trying drove the car to the bank. And he said, I had no idea that there was going to be a bank robbery. My friend came to me and said, would I drive him downtown? And he had to go to the bank. He wanted to make a withdrawal. Who knew that that meant bank robbery? So I drove him downtown. He came out running from the bank. I was surprised, but I didn't know there was a bank robbery. Okay. So there was a very fine FBI agent, and when the defendant was arrested, he said, can I call someone? The FBI agent said, sure. The FBI agent took down the number of the person he called. He called a friend to arrange for bail. The FBI agent found the friend, went out and interviewed him, and said, look, his defense is that he was just an innocent driver, that this fellow Smith came and asked him. To which the friend who, he called that night said, that's his defense? I mean, he told me that 3 weeks before that, he went to another bank with the guy, and the guy ran out of the bank, and he had money in a bag, and the bag blew up, and there was money all over the sidewalk, right? And he did it again, are you telling me? Right? Now, that may not be the best of friends, but that's a very good government witness. And basically, the notion is, the defense is, I'm just the innocent driver, to which the answer is, not a second time. Right? If your friend says to you, drive me to the bank, I want to make a withdrawal, once you can do it. If you drive him a second time when he wants to say withdrawal, after he's ran out of the bank and the money's exploded on the sidewalk,